This meeting is being recorded.
Great. Thank you very much once again. Good evening.
Good
Topic today
evening.
is part 2 of the force majeure clause. We had great discussions last fortnight. The recording is available on my YouTube channel. You'll be able to find it easily, youtube.com/damandevsu. And all recordings will be available there. There are a few other recordings also. Good source, I would say, for BCM risk, crisis, organizational resilience, operational resilience. That's all that I know. Let's start. I'll share my screen first. Quick introductions. Me, the host. The name is Daman Dev Sood, about 35 years in industry, 16 years in this domain. In the past, we used to keep it simple, just BCM risk crisis separately. Now the new terms, resilience, operational resilience, or the biggest one I say is organizational resilience. I have won awards multiple times, nationally, globally. Trainer, consultant, auditor, assessor, author, speaker, etc., etc. With us, we have 3 personalities today. In the panel, Anand Sampath, who is founder and CEO of Udbata Technologies Private Limited. Also, Kamal Dave, advocate and arbitrator, specialization on cyber law. And we have Aniket Kumar as the judge. Aniket is a legal and taxation expert who has been associated with several startups and innovative companies and has about 2 decades experience. So this is fun come learn activity. There's really no judging. So to the panelists, also to the judge, no psychological pressure from my side. As judge, you will give your own perspective on points that we discussed, and in the end, kind of summarization, overall impression that you will have. That's what the judging would mean, not more than that. So welcome to this show once again. And let's look at the first question. What is force majeure clause? We had discussions around this, but I'm repeating this. Only this question. What is force majeure clause according to you? And I'll take this off so that we come in front of each other. Go one by one. Anand, would you like to start first?
Sure. So essentially, it's accommodating a situation that may not be foreseen and trying to clarify what would be the responsibilities and obligations if that unforeseen obligation event were to happen. In a way, it's a residual clause that protects or is intended to protect either of the parties in case those scenarios were to happen.
All right. Right. Thank you very much. Kamal, would you like to go ahead? You're on mute. Yes.
Yeah. Sorry. The rule is we have been dealing with this very subject topic on last many lectures. So the rule is that when 2 parties are there between a contract, if one agrees to do something for another, the other party has to pay the price or do something. There has to be reciprocal promises, and in the end, what one is supposed to do and what another is supposed to get. Usually, it is a financial thing. It is liquidated. Yeah. Now, there could be exceptions. So that is one of the major things. Exception to this very rule that one person has to pay the price. 2 persons are legal entities. Individual, it could be individual or a corporate, whatever the case may be. So those 2 enterprises, those 2 persons, one has to say something, one has to do something for another to in exchange of some price.
Okay.
Sorry, actually my health is not good. I'm having sore throat, cold fever. So So that is one of the basic things. Now, in that scenario, the exception is force majeure, which has been with the happening of this COVID-19, this has come into light.
Okay.
Very great limelight.
Okay.
So what exactly is this? It is an exception that under these very circumstances, which are beyond the control of individual, the person may be exempted from paying the price or performing his part of the means making
Right.
good his part of the promise.
Right. Thank you very much. Ankit, Aniket, my apologies. Aniket, would like to go ahead? Yes.
So, force majeure is something, for common man. I don't actually practice as a litigation lawyer. I practice as an advisor only. So what I think in common parlance, there was a movie, Oh My God.
Yes.
Which was on this only, that act of force majeure means act of God, something that these two parties have not envisioned. And Indian law, force majeure is not provided in law itself. Force majeure is what is provided in law is doctrine of frustration, which is different from force majeure. So force majeure law exists only because of the contractual clause. So the agreement does not have a clause for force majeure. There is no, the parties cannot seek protection under force majeure clause. This was very recently when COVID epidemic hit India. The problem was certain retail companies faced that they had an agreement where force majeure clause was not present at all.
Mm-hmm.
The companies claimed that we are not supposed to pay rent because this is hit by force majeure. Then said there is no force majeure clause in the agreement. So here, force majeure is act of God, something neither party have foreseen. But this need to be clearly mentioned that what constitutes force majeure in the contract clause itself. So they mention epidemic, war, machinery background. There was Supreme Court also where they said the machinery background strike can be considered force majeure. But most important is that force majeure is not defined in law itself. It is defined in the clause we are talking about.
Okay, great. Thank you very much. So a couple of points, and I didn't have that question, but based on your responses, I'm asking this question. And I'll go to Anand at the last this time. I'll start with Kamal.
Yeah.
Do you know any case, either you yourself or anyone, either your clients or known ones, have ever invoked force majeure clause?
Actually, it was not exactly force majeure. I'm actually handling at present. I'm handling a particular circumstances. It is not a force majeure, but the thing is, in that one, there are circumstances where reciprocal promises are there. One has to perform. One can only perform the part of the duty when other is providing him the opportunity. That is provided by Section 53 of Indian Contract Act.
Okay.
Now there is a contingency also. There is a provision for contingency.
Right.
Where two things are there. When on a particular happening of a contingency, if this thing happens, then entire thing is void. Contract is voidable at either it could be void or it could be voidable at the instance of the party who is bearing that very, who is incapable of performing that way.
All right, great, thanks. Aniket, do you have some views on?
I have been working with some retail companies. So this epidemic, they faced this problem. So in one of the companies, this clause was there. So we talked to the landlord, mentioned the clause, and negotiated with him based on the clause that legally this is something which was provided. There was issue about whether epidemic is mentioned or not. Another company where this clause was not there, landlord simply said, the company said, we are going belly up. So I was part of that negotiation. The company agreed to pay certain rent. So that's what I handled from the company side. None of the matters went to litigation.
Aniket, hold on. My question was, do you know any cases where this clause has been invoked?
I have not handled personally. There is a Supreme Court case, I am aware, where it was mentioned that strike or breakdown of machinery constitutes force majeure, provided is provided in the agreement itself.
Okay. So it seems we still are in that boat when we are saying perhaps we do not know any or much cases where it really has been invoked. But Anand, your views we had last time also, but you can repeat.
Yeah. So not directly, Daman, but I had talked about two scenarios. Scenario one is where insurance companies who had to pay up for people who fell sick during COVID, they tried to avoid the payout by requesting this thing under force majeure. But my understanding is that was denied, right, there in that particular case. But in another scenario, especially for construction companies where they need to perform for governments, and obviously there are liquidated damages, I think there were waivers provided by the government during the time of COVID. And I'd imagine that this waiver was provided under the umbrella of the force majeure. So that's how I would probably state it, but no direct experience.
Okay. I'll say what I had been saying, how I explain this. What does it mean? It's legal. First point is it's a legal language, so it's difficult. All contexts are difficult.
Right.
So I make my own way of simplified version. I say, if let's play a role. You all, Anand, Kamal, Aniket, Shweta, Amitwa, you all are customers. I'm the vendor. So I'm sitting or standing with folded hands. Dear customer, please do not penalize me if I'm not able to deliver to you what I committed because of something which is beyond my reasonable control. This is how I would say that's what this means. And this is two ways also, that there may be something wrong at your end as well, which then becomes, we had a discussion around that. What do I expect? That I'm not delivered, but you still pay me? Or will you be willing to pay? Right? I'm ready to deliver, but you're not ready to receive it because there is a disaster at your end. You are invoking the force majeure clause. I would expect my payment to come, even if delivery is not happening, but delivery is ready. So if you want to give quick views around this also, the way I have narrated it, right, wrong, or fun, Daman, because we are saying this is fun activity also. And you may like to go ahead first.
Yeah, I think that this is a very apt summary of what it stands for. The only thing is, I may want to do this even without invoking force majeure. So what I would just like to say is that I can always stand in front of Daman with folded hands and say, "Maaf kijiye, Damanji." I don't have to invoke a force majeure to make that happen. You might still say it's okay and it could happen, on mail, right? And if you want to refer to a contract, you would. I'd imagine that this situation will come where one of the parties is not in agreement, and therefore you are invoking force majeure. So that would be my only add-on there. Otherwise, if both are agreeing, then that force majeure could be skipped, is what I would imagine.
Good.
Otherwise, it's the right explanation. The simplest way in which I think.
Yeah, sorry. Actually, mediation is one of the things. Conciliation and mediation is one of the major part which plays such important role, that two parties, if they agree together, they may agree to particular thing.
Okay.
They may waive off the things. However, it has to be the entire test has to be of a person, of a reasonable or prudent, reasonable person.
Right.
The test has to be that one. You can't have unlimited or means whatever you say, that
open-ended, yeah,
unsubstantial, open-ended thing.
Okay, great. Thank you very much. Aniket, we are still able to respond even if you're traveling. Yes, great.
So I agree with Kamal that the way is that you talk to, go with folding hands to the vendor, talk to him, convince him that this is my problem, and both of us have to think about long term. So long-term association require that you make some compromises, I make some compromises. I do not have, I'm not in the capacity to receive. Given some time, I may be.
Okay.
So you wait on me. Other thing is that if the vendor forces that no, you have to take delivery anyway. So then I will come back to mention that contract clause, that this is a clause mentioned here. Sorry. And frankly, I will advise my client also that don't deal with the vendor. This is a business relationships are give and take. Somebody who is not willing to listen to you, in future, when you are well, you avoid dealing with this.
Okay. So the sense that I'm getting from all three of you is that more than this contract or agreement or the clause, it seems the relationship is very important. And then
Correct.
I say thanks. I say we need to develop, maintain, and nurture our relationships, which then takes me to a different degree. When I start talking of organizational resilience, that relationship building, maintaining, and enhancement, nurturing is a very important component in organizational resilience. So that discussion we'll do on some other day. But before I conclude, yes, Kamal.
Actually, relationship is the basis of all contracts.
Is the basis of all contracts? Okay,
Yeah.
I like that. I like that.
When I have a new client, I explain to him that, look, the contracts come into play only when relationship goes bad. Otherwise, if you two are agreeing, any and every clause can be modified.
I like that. I have been making this statement myself also. But if we say that contract is to be looked only if their relationships are sore, right? Then in the contract, we have actually the main delivery also, what I'm supposed to do for you and what you will be paying me. So it's not that we do not need to look at contract at all. Maybe those negative clauses, if we want to call this is a negative clause, whenever there is a penalty clause, those negative clauses are to be looked only if the relationships are sore.
Correct. And also the contract comes into play when one person is leaving and his replacement is coming. So you need to go to that guy with contract copy and explain this is what our relationship. Right. So you have misunderstood. This is our relationship, and based on that, he says, okay, no, we need to modify. We modify.
Great. Thank you very much. So I wanted to spend a little more time on the second question, the insurance for BCM. While concluding, there's still one question in mind, and for all three of you. When we talk of force majeure clause, is it an agreement or is it a contract?
Should I start?
Yes, please.
Yeah, it is a part of the contract. It is those eventualities which are exceptions to the rule. That is what I stated in my earlier thing. That it is an exception to the general rule. Actually, so long as the relationship between the two parties, entities are good, there won't be any legal complications. As soon as the relationship turns sour, then everything comes about this, all those things. Now, what should be, that is why while drafting a contract, it has to be contemplated in mind that under those circumstances, when the relationship won't be good, it would be sour, then what should be the things? The law provides that it has to be reasonable, then it has to be, the compensation has to be, if it is provided in the contract itself, then that would lead to reduce the eventualities of having conflict, more of conflict. You just list out all those things that the party one will do for party two and party two will do for party one. And under those circumstances, this will pay this much amount of compensation. Then that has to come into force.
Great. Thank you very much. And your views before we go to the judge for his comments.
Yeah, so I sorry, was that Aniket? Please go ahead, Aniket.
No, you please. Sorry.
Daman, was it me that you wanted to?
Yes, Anand.
Yeah. So I just like to add that basically the way the force majeure comes to life is because you have exhausted all possible reasonable scenarios in the rest of the contract, right? So you say if A happens, this is what we will do. If B happens, this is what we'll do. But you can only go up to C or D. You can't go all the way up to Z because you don't know what the others are, right? So that's where you put it in the residual and say that, okay, we've managed to think about A to D, but anything else basically falls under Z. And in the case of Z, basically this is what we agree, disagree, or we don't want to, we want to get waived, right? So that's how I would imagine this. I think that's the only thing I want to add. Otherwise, Kamal is spot on. Yes.
Thanks. Aniket.
What the question you asked is whether force majeure is agreement or contract.
Yes.
The answer lies in the definition of contract in Indian Contract Act, Section 2 Clause H, which says that an agreement contract is an agreement enforceable at law. So it means there are two types of agreements. One, those who are enforceable at law. One, those who are not. So force majeure is something clause. If it is present in agreement, it is enforceable at law. So force majeure, I believe, is a contract.
Okay. So what about NDA? NDA also, I believe, is enforceable in the court of law.
Yes.
So why do we call NDA an agreement but force majeure contract? So a bit confusion, I'm saying, for myself itself.
As I say, contract and agreement. There are two types of agreement. Those which are enforceable at law, those which are not.
Right.
So contract, when you mention even simple service agreement, are mentioned as agreement.
Right.
But if these agreements are enforceable in law, then they are contract. And if they are not contract.
So I'll conclude by saying this or asking this question. So NDA also is enforceable. Am I right?
No, not exactly.
No.
Not exactly.
But why not? There are penalties there also. There are some commitments there also.
Coming to that very point. NDA would be enforceable only under those circumstances when two parties have come to the contract and agreed to do those things. If you say just there's an NDA in your website and party one agrees to do something and whatever is in return, you can't enforce because those things have to be explained to that very person. Though those two parties must have concluded that this is their intention to do.
Yes. So generally, I'm saying I have not seen NDA published on website. I'm saying if I agree to provide some services to you, we two write an NDA, we both sign it. I've seen one-way NDAs also. Client enforces upon the vendor, but mostly I've seen the two-party or two-way.
Those are not enforceable. If it is enforced by one party and not agreed by other party, then it can't be enforced.
All right.
Any unreasonable restriction which is made in the contract can be struck aside.
I think while we had that debate on NDA earlier, it seems I'll have to do part 3 of that as well. Different views coming today because it seems we understand two panelists have more knowledge of the law compared to the rest of us. All right. So it's good.
I'm a student. I'm a student of law. So I'm understanding. I'm learning. This is a learning experience.
I'm a lifelong learner myself. Learning and sharing is forever. So before we change the gear, we go to the second topic, part 2 of the debate. Shweta and Amitava, if you have any questions around this force majeure clause, you can unmute and ask question. You can switch on the camera also if you wish.
No questions from my end on force majeure clause. Although NDA is it non-disclosure agreement we're talking about?
Yes, not disclosure. Yes. Great. Amitava, any question from you? So I assume no questions now, but you can ask the question. Yes, you are going on mute. Yes, Amitava. We can't hear you. You may like to type in the chat box. We'll see that also. Great. So second question for this evening, morning or afternoon's debate, insurance for BCM. And I'm starting with this statement. My view is if I buy insurance, there is no need to implement BCM. BCM is useless because I have purchased insurance. And I would like to open the debate with this statement that I have made or my views. And we can start with Anand perhaps.
So insurance is going to help you pay for the loss that you have incurred. And when insurance contracts are agreed, the belief is that the company is going to have some minimum controls in place. Whether you want to call it BCM is a technicality because it's a discipline, right? But there are certain basic controls that are required in place. But this is still going to only support you from recovering a loss that you have incurred.
Okay.
It is not going to help you start resuming your services that you need to provide to your client or customer, assuming that that's the relationship, right? And therefore they are not necessarily, they don't mean the same thing. The purpose of insurance is different, and the purpose of BCM, in my opinion, is significantly different.
All right. Thank you very much. Kamal.
Sorry. What exactly is insurance is, we have to understand in another context. Originally, the contract is between two parties. Now, either party who defaults, he is liable to pay something to the other party,
Right.
as per the normal contract. Under those circumstances, under those circumstances, the role of insurance company that comes into play. That whatever, say suppose he is liable to pay for something, then the person will not pay because he is paid the insurance. Then it has to be made good by the insurance company.
Okay.
Will make good, but there is a clause. There is a prudent reasonable man clause, that you can't claim anything under all circumstances, that even irrespective of the fact that I am not legally conforming to the standards which are prescribed in those very things, which I ought to have done, then the insurance company can always refuse. So it is not for benefiting, it is making good of any loss which may be suffered because of breach of contract.
That was
That
my
is my
next question, but it seems you are a mind reader, so you have gone deep into that already. I may ask that once again so that we spend a little more time around that. Making money out of insurance, that's how I call it. But Aniket, your views on my first one. I said, if I have purchased insurance, there is no BCM required.
No, lot depends on the wording of insurance clause. Okay. And act of God is something which has always been a bone of contents, this prudence thing. And normally, you have seen this has been debated and the courts have given differing judgments.
Right.
Okay. So, but still here, insurance law is something where my knowledge is limited. I am more of a technology and corporate law person.
Okay. Okay.
Okay. So I will defer to whatever has said been.
Okay. Thank you very much. But we'll still request you to give your point of view as a judge. Or otherwise, I said there is no judging actually. You're just giving your point of view also on each point that we're discussing. So I'm happy to. Yes.
So as I said, lot will depend on the way clause is worded.
Okay.
And we lawyers, what we do is what Hindi mein kehte hain, baal ki khal nikalna. We try to find meanings where no meanings were intended.
You're scaring me.
So the wording this plays a big role.
Right. Understood. Understood. So I'm happy to amend my statement when I said if I got the insurance, there is no BCM required or BCM is useless. I'm happy to amend that view that it's not a replacement. Insurance is not a replacement of or for BCM. Both are required. Personally, I've been saying this, what's the value in BCM? I have faced this myself. That if I've got, as Anand was saying, I'm adding a little into that line. If I have BCM or if I have good BCM, the insurance company is willing to give me good insurance. Either the cover is increased or the premium is reduced, and that's the return on investment on BCM. This is all I've been selling it internally as well as externally. So I like that. When I change or attempt to change the gear, what I'm looking from you as experts is please talk about some types of insurances which are close to BCM or which support BCM, or where BCM is close to insurance. Right? So that's the topic. Insurance was BCM. There are perhaps 100 types of insurances available, which are close to BCM. That's what the question I'm looking at. If you can name few and then perhaps explain a little bit within the time limits that we have. Kamal, do you want to go first?
I think Anand should start with.
I'm sorry?
No, he would.
All right, yeah. Go ahead, please.
Yeah. So I can directly remember one, Daman, where we have this concept called loss of profit policy.
Mhm.
And the loss of profit policy uh, comes into place when, let us say, a particular manufacturing unit is unable to produce because of a major incident. And that incident could be, let's say, a fire incident, or it could be, a particular specific insurable incident or event, because it has to be an insurable event, right? It could be a peril, it could be a fire, it could be anything. Now, in such a case, very clearly, it's not just the value of the stock that is destroyed or the value of assets that's destroyed, but also the notional profit that ideally the company could have been made. So I can see that directly. I think that's one very clear area that maybe 10 years back companies were not taking as much, but in the past 10 years they understand that there's significant loss of opportunity, and possibly the insurance laws have encouraged companies to claim that.
Okay.
And I see that as a very direct, I would say, application of BCM, because that's the real loss.
Okay.
I I probably need a few minutes to think about any other situation, because at the end of the day, it's the serviceability to the company that matters, right?
I'll give you some ideas.
Yeah, I'd imagine that all of the liability insurances that come into play, in a certain sense, provide for this, whether it is cyber, whether it is environmental, whether it is any of these liability insurance. I
Okay.
think they play partly the role of making good the loss, because the loss is not just the loss that the company has incurred. It could be something significantly beyond that.
Mhm.
So it can translate to a loss that maybe some other third party has incurred because of this, which otherwise for you would be a significant cost, and maybe these insurances cover it, right? There are insurances now that, as I start talking, a third example I could give for sure is something that we were trying to evaluate for our company long back, called political risk insurance.
Which one?
Exactly the situation, political risk insurance.
Political risk.
So today, for example, right now, exactly this specific incident happened in 2014 also, the Crimean War, right, at Ukraine, along with
Right.
Russia. And
Mhm.
at that point in time, if a company had depended on, say, business from Russia or from Ukraine, and if this war played out, obviously there would be loss of business. There would be inability to service. Obviously, you would have loss of profits too. So political risk insurance again helps companies recover in such cases, but you have to obviously take it when there is good times. Today you're going to go and ask, nobody's going to give you that insurance. I can think of these three possible scenarios. I wouldn't say strictly BCM, but definitely losses are going to be in the nature of loss of profit and not just the absolute
Okay.
cost or loss of asset. I'll stop here.
Great. Thanks. Kamal, do you want to add?
Yeah. First of
Subtract.
all, I must admit that I am not from insurance law. I don't practice insurance law. First thing, that is disclaimer. So maybe at some point I may be wrong. But the
All right.
question is, there
Okay.
has to be test of reasonableness.
Right.
Insurance will only make good only if they, say suppose you have made a business continuity plan that is there in place. Now what
Right.
all eventualities are there in those very business continuity plan are there. If there is a deviation from that one, and if the party is in default of any deviation, then definitely, because it has to, the test is that of a prudent reasonable person. If there is a deviation from those very parameters, say suppose in considering the case of cyber security, now that is one of the major things that means companies are on to this insurance, cyber insurance is going on. Now under those circumstances, say suppose if a company does not, that is the first thing, does not update any of the licenses of either the software or operating system itself, or the antiviruses, or all those measures. So suppose some advisories have been given by certain or all those agencies which are into security. If those measures are not taken, secondly, had they taken those security, what you say, security tests, that is what exactly they carry out security tests to test the vulnerability of the VAPT.
Penetration
Yes.
test, they call it.
Yes.
Yeah, VAPT test. If
Yeah.
they don't comply with those very circumstances, then they have not passed the test of reasonableness. So under those circumstances, say, suppose if a company enters into losses because of any unforeseen circumstances, there the insurance company can't pay that. Mitigation has to be, it has to comply with those circumstances which are there in business continuity plan. If it is,
Correct.
secondly, it has to be, if the damages, whatever is there, you can't have unreasonable damages. You can't have damages. There is a check. There is a remoteness of damage. Either you make it in the clause itself, agreement itself, or the company, it is only for compensation of the loss. It is not for making rich. It is compensation of loss. Either you make it, provide the provision in clause, as a clause in the agreement itself, or you, sorry, my throat is very sore.
And
Either you make a compensation or you provide that one in the agreement itself. So under those various circumstances, insurance company can always avoid paying the law, insurance.
I'll attempt to give it a different color soon. But before I do that, Aniket, your turn. Aniket, can you hear us? He's been driving, we know that. So perhaps she's not able to come into this one. So I'll move on and we'll wait, Aniket, if you can come back. So I understood, especially when Anand was speaking, loss of profit. So am I correct in making this understanding or belief that an insurance will only give me relief of or from profits that I would have lost? Let me say a little more. When there is a BCM situation, I have faced a disaster in my company. I'm not able to deliver, due to which I lose revenues, due to which I lose profits, and due to which there may be penalties also that I would have to pay. So in these three, 1, 2, 3, or only one is supported by an insurance. What is that? Or is it all? I thought it's all.
So I'd imagine that loss of profit very clearly is because of loss of profit, which means that there's been a flood, a fire, an event, and as a result of which what you could have otherwise sold and made money out of by selling it to your clients, that is the amount that the insurance company is going to recover. It is not going to pay you for your penalties. But there are other insurances that you can take, if I'm not mistaken, errors and omissions, say for example. And these insurances allow you for failure of, again, as Kamal said, these have to be under reasonable circumstances. You've done your bit and they've not worked out, and therefore, you ended up getting sued by a client, or there's a penalty on you. And those errors and omissions actually help you there. So it may not be one contract, but you may have to. If you have three components, like you said, Damanji, the asset, the loss of profit, and let's say the penalty, maybe the asset and the loss of profit can be taken in by this loss of profit insurance, because it also pays for the asset. And the other one needs to be taken by a different insurance. But in this scenario, it is possible. Maybe in a different scenario, like Kamal said, it may not be possible if you're trying to provide a notional loss, which is not real, right? So unless and until there is a suit by a particular customer that you are fighting in a court and then you lose, and then you go back and say, okay, this is the money I want to claim, I think then there's a real impact. You can't say that, that there's the potential loss, so I need to, kind of this thing. So generally, reimbursements for cybersecurity insurance have been for the losses that the companies have eventually been sued for, that they have to pay, not beyond that, right? So it would have been, it has to be proved that it's a loss. And like Kamal said before, that you have your obligations to complete to make sure that that loss was reasonably defended before it actually happened. So long answer, but I hope it answered.
Thanks. Kamal.
Yeah, I think it depends upon, again, the scenario. Right. Penalty, if it is there included in the clause itself, then definitely they will pay for the penalty as well.
Mhm.
You
Yes.
can't exclude that one. If it is, it has to be included. If
Yes.
the penalty, if that such penalty, if that is imposed pursuant to the negligence on my part, on part of their party, then that won't be paid.
Okay.
If it is due to negligence on the part of the party, then that won't be reimbursed, because it is because of his direct negligence to carry out such things. It is only
Which Kamal is a little confusing for me. So I bring in, for example, which is easily understood by most of us, I would say, including me, life insurance. I have purchased life insurance for myself and I die. Even if I die knowing not suicide, I think suicide is not covered in life insurance. But otherwise, I've died knowingly. My mistake, I made a mistake. I was crossing on signal, red signal, for example. I shouldn't cross and I was hit and I died. I believe that insurance is
that
paid.
is included. That is payable. Yeah, that is a condition that you have already stated, na, that suicide is excluded. It is because that only, na. It is a person's fault, individual's fault. Because of it, he committed suicide. So that is why insurance won't be paid.
No, fault is even crossing the road on red signal.
No, crossing the road may not be a fault. That is included in a part of it, because though that is a scenario. Again, those are circumstances are there. Those have to be seen. Say suppose a person, there is a running traffic, and during that one a person tries to cross that way, then he is at fault. Then insurance company won't pay.
All right. Okay.
Say suppose a driver is there who does not hold a valid driving license, then insurance company won't be liable to indemnify. So those are the circumstances which have been excluded.
All right. Okay.
Test of reasonableness. This is all is test of reasonableness.
All right. Thanks. Aniket, are you able to join us? Yes.
Hello?
Yes, please.
As I said, I will defer here to the what I have been said by other people, because these are areas where I am not very good.
That's okay. We all are learning. Yes, we all are learning. So you can have your views, even if someone may say, yeah, okay, I disagree with that. That's why we are having this debate, which is fun come learn activity. What is your expectation? You can say that. You don't know. Someone, this is what my expectation is.
Is the retail or business side of law and this thing, blockchain and other technologies.
Right. Okay. Let me name another. Yes, Anand, you want to speak?
Yeah, I just wanted to add one more comment which will probably help in easing out this doubt. So generally in India, and this is, I'm just saying deliberately in India, because abroad there are different kinds of insurance products that are available. Generally in India, insurance is not offered for events or risks that are deliberately taken. So let us say I am willingly taking a risk for my business.
Right.
Can I go and insure it? There may be a product theoretically possible. Maybe there's a product available outside India, but it's not permitted by the insurance law in India. So these have to be events, perils, as they use the word, that are not foreseen in the normal circumstance of the business. So after that, obviously, it's the premium that decides whether, if you're taking care of it, risk management, BCM, जो भी आप कर रहे हो, उसके basis पे, जैसे आपने बोला था, the sum assured or the premium can change. But fundamentally, you cannot be insured for a risk that the company is willingly taking. I just wanted to add that one comment, and maybe some of that can answer this. And exactly like Kamal said, insurance will not allow you to make a profit. It's not there, and it will not be allowed.
Right. Okay.
So those are two things which are definitely there.
I will add to this. I will add to this one. Yes. Now the domain of drone technology is coming.
Yes.
Now with IoT and drones, it may fail at any point of time. You can't be sure what will be the end result of those very two technologies. So under those circumstances, if it is a failure because of any non-compliance to the security measure, that even though those risks have been covered under the insurance company, but how can the company will pay? Means that is my viewpoint.
Okay, all right. Thanks. I would like to go back to Anand for a few seconds. Anand, you are a risk champion, so I wouldn't dare challenging you. But when you said a risk that has been taken willingly will not be insured or cannot be insured, or the insurance company wouldn't like to insure.
Right.
The good practice is this: what I teach when I teach risk management, that first point is to bring the risks on the paper. Whatever risks are possible for you, those should be documented. That's the first identification. So the moment I have got it, now flood, fire, earthquake, pandemic, I'm saying is in my risk list, which means I have known these. And some of these would be accepted also, right? Which means the insurance company will not give insurance, or then there's nothing left to be covered through the insurance, nothing left to be insured, because all those are willingly taken risks.
Yes. So we are not talking about the risk or the risk management per se. We are talking about the conditions that bring about the risk, right? So what I mean by this is a classic example is in the pharma industry, we have something called launch at risk. This is basically, in US as well as Indian companies have been very good at challenging innovator patents, right? So the business model is to develop non-infringing IP processes, and you want to challenge the innovator patent. If you win, you get a bumper, income. If you lose, you end up paying damages. Now, this is a business decision taken by a company. The condition of the risk emanates because of the decision by the company. The condition of the risk is not something that is not in the control of the company. It's not like it's not in the control like a flood or a fire. This is something that has emanated from a company. It's a business decision. Those business risks which are based on business decisions by company are generally not insurable. So that is the area that I'm talking about.
Great. Thank you very
It's
much.
not about the strength of the risk management controller.
Thank you.
I'll add to this one. In
Yes.
India, the arbitration law provides for any eventualities, because that you can deal with any of it is basically a contract.
Okay.
And all those contracts can be dealt with under arbitration.
All right.
Irrespective of the fact that whether those are in India or not.
Okay.
Either you can have, say, suppose it's a company is there, which is established in many of the countries. They can always go in. And another thing is, there are something called third-party litigations, means arbitrations, wherein the party who is funding, the third-party funding is there for contesting the suit. In India, it is not there.
Okay.
First disclaimer is that in India it is not there. Third-party litigation means those persons would definitely file, or either they will contest the case, or they will, as a claimant, they will file that very case. Okay. And the entire thing that will be funded by that third-party funders.
Good.
That's an arbitration.
Yeah. Thank you very much. Looking at the time, I'm willing to go a bit fast here. I still have 2 points to talk about. Teaching BCM, I would have talked about 2 more types of insurances which are close to BCM. One of them I call BI, business interruption insurance. And then I have a story around this. I couldn't get that text as I was doing with NDA and force majeure clause. I had brought in the text from real clauses. I missed to bring this, but there was a text there in business interruption insurance that it will help you to come back to where you were. You cannot be better than that. And then a story, which is a story I do not recollect. I read this 15 years ago, 14 years ago. I do not have the real source with me. But story goes like this, that in UK, there are councils. Right? As we have municipal corporation, for example, in some cities, some states and countries, there are councils. So a council in one of the cities in UK had built a bridge. That's what the councils would do. Municipal corporations would do. They had built a bridge over a river, and they had purchased business interruption insurance. And once, due to heavy rains and floods, that bridge got washed away. And this council woke up. We had business interruption insurance. Let's claim it. And the company said, yes, please submit the papers and we will process it. And at that time, those great minds thought and said that we have learned lesson. Even technology has improved. We will build a better bridge now. And the claim was rejected. You couldn't be better than what you were. So in such case, two questions that come to mind. Is this correct interpretation that I have got from the story? Second, then technology keeps improving. I cannot have the same old bridge built now after 20, 30 years, which means my insurance claim will always be rejected. Then there is no point in buying the business interruption insurance. I have actually made a loss in paying that premium. Are you on mute, Kamal?
Not exactly. Again, the situation and circumstances change according to the agreement between the parties and the current situation. When you say that there is an interruption that has been covered as a part of BCM, all those eventualities have been taken into consideration while forming that very contract, irrespective of the fact that today the same very product of insurance product may cater to loss of X thing. Tomorrow it may cater to the loss of Y thing. The insurance product may not be bad, but eventualities which have been mentioned or had been stated in all your BCM, all those business initiative, into this one, what you say, interruptions, all those have been taken care of in the BCM itself.
Okay.
So you can't really say that the product may or may not be good. That is a different part of the story. But the thing is that.
So what is your recommendation? I should buy business interruption insurance.
Definitely.
It's not waste of money.
Yeah, definitely. It is not a waste of money. Right. Because under those circumstances, you can't, obviously you can't make benefit out of it. You can't make profit out of it. Good. But the thing is, if it is providing you insurance to reach to that very level, because you are paying the premium for a particular thing, eventuality, a particular eventuality which has been taken care of in that very insurance. And that clause takes care of that very thing.
Thank you very much. Anand, your views?
So business interruption insurance should be taken.
Should be taken.
I just quickly checked and realized that loss of profit and BI are the same. They are the synonyms. So they are the same. So the purpose is the same.
So it covers
to make
profit.
Up for your loss.
Loss of profit.
Yeah, it covers, yeah. Apparently, it also covers the shortage of working capital also in case that is required because of this loss, right? So BI and loss of profit are synonyms. Okay. But to answer your question specifically, clearly, yes, this is what companies have been doing in the last 10 years. Everyone has been taking. I think it's because they realize the futility of their risk management or BCM programs, and they realize that that's a genuine loss that nobody's going to make good.
Okay.
And therefore, it's being taken. That is the simplest thing to look at. The second part of your question was about what happens if I have changed the asset to a better asset and whether I should get or not get. I think the general principle is every year when you pay insurance premium, you're always paying it on the replacement basis. It is never on original cost, right? And then that replacement cost, it may not be 100% of original cost, but let us say computers that you would have otherwise, insured at 1 lakh rupees 15 years ago will now be at 50,000 rupees. So they're always going to insure at replacement cost.
Right.
And this also means that the asset is also going to be replaced to the current technology. So I'd imagine that if that was the scenario given to you, I think that that's not a very fair expectation. I think the insurance claim should have been honored.
Should be honored. Okay, good. Thank you very much. Aniket, are you still able to speak? He wrote that he had entered an area where there was a lot of noise and
he can't speak and he may not be able to speak. Yes, he probably
We'll wait
that.
for a few seconds, Aniket, if you're hearing us and if he can come back. The next one, which is the last one for tonight, only 1 minute per person. So we need to go fast. This is my belief that this is also an insurance which is close to BCM. That's why I'm bringing it. Keyman insurance. So is Keyman insurance close to BCM and shall that be taken by the companies? Yes or no?
Mr. Anand should start with. Actually, I didn't understood the term technology.
Okay, Keyman insurance, quickly I'll say, Keyman, generally a life insurance is taken by you only. I cannot buy life insurance for you. The company cannot buy life insurance for you. You need to pay premium, and you means your spouse, your family will get the proceeds if that claim has to be processed. Right? Keyman insurance is a type of insurance that the company can buy for you on your life. Company pays the premium and company gets the money if the claim has to be processed. Right? And it is taken for Keyman of the company, which means CXO level only. So it may be very costly also, it may be big amount also. That's what Keyman insurance is.
So Anand should start with, I think.
Yeah, I'd say that is more fitter connect than even loss of profit or BI. So I think that should be taken, and I would say that that's a very good decision by the company if they decide to go for it. But Keyman insurance, for logical reasons, are Keyman only because the belief is that the company cannot survive if that Keyman is no more.
Right.
And that's the reason.
That's what I'm saying is
So
BCM
everyone,
situation, if the CEO dies,
yes,
for example.
Yeah, but it doesn't, the company is not going to fail if a large company CEO dies, right? It's usually going to happen when the company is still a fledgling and still disproportionately depends on that one key man. That's the reason why we are calling it key man, right? So yes, that's the way it is. So I wouldn't say very large companies who have systems and processes and who don't depend on one person for them to continue and service. I don't think for them it matters. But the concept of keyman itself assumes that the company is dependent on that keyman. Therefore, the answer is a big yes.
Great. Thank you very much. I think
it
sorry,
can be.
Kamal, sorry. Yes, go ahead, please.
You can always, means the company can always go in for keyman. But again, that has to be, means what loss is incurred by that one.
Right.
That has to be
It's only to that extent.
liquidated. Yeah, liquidated in terms, those very terms.
Right.
You have to assess the loss.
Yes. So the way I had been advocating companies should buy Keyman insurance would be like this, that even if I listening to Anand, it seems then the big corporates shouldn't buy the Keyman insurance. Not going into debate on that point. The way I would sell it is that if
I'll just interrupt. I think it is good for big corporates to go in for Keyman insurances rather than a small company going in for, because the insurance premium which would be there on those very things, and the decision of entire company of a big stature depends on that very key personnel.
Right.
And definitely you will have to find a substitute for that one.
Yeah, so it may not happen like this the way I explain, but I still explain just to sell the concept or explain the concept that CEO dies due to any reason all of a sudden, whether small or big company. So the customers would have questions whether now this company will be able to deliver to us because CEO has died, the guide has died, the leader has died. Due to which the employees would have doubt whether our salaries would come or not now. Something like that. So this is business continuity situation. If company has purchased the Keyman insurance, which is huge amount, assume 50 crore rupees, 10 crore rupees on my head, right? Daman dies. Company has that 50 crore rupees or 10 crore rupees in hand immediately to give assurance to employees, first of all. At least for next 6 months, your salary will come, this is the money. Or otherwise, there is someone called Kamal, the best CEO in the world. The previous one, Daman, was getting 1 crore only. We will pay him 5 crore and we'll get him. He will run the company successfully. And then this is how we'll ensure continuity of the business. This is how I had been explaining the concept of need to go for Keyman insurance.
I have a different opinion about this one. You can't ensure the employees that they will be paid for those this one. It is basically for finding a suitable suitable person for that very post. It is that replacement.
Right.
And that is a period, gestation period is there to get that get the company out of that very situation, to under those very gestation period that you can replace that very person with an equally skilled person. It is for that. It is not for having a replacement or paying the wages or salary or means whatever the case may be.
Okay.
That is my perception.
All right. Okay. Aniket, are you there? It seems he cannot. Okay. So while closing, I'll request Shweta, Amitava, once again, if you have any questions or any comments, observations, etc., unmute, switch on the camera, and speak, please.
No questions from my end. Thanks.
Great. I hope you found the
No
session
questions
useful.
from
Shweta?
my end also. I don't know whether I'm audible or not.
You
Daman,
are, but
last
feeble,
time.
yes.
Yeah, I think I have some issues on the microphone. But n- uh, I have a little, difference of opinion. I'll just take 30 seconds. I'll not take much more time. We are already an hour. Keyman insurance, like what Anand told, and I completely agree with Anand that it may not be applicable for the large companies. Otherwise, the whole purpose of succession planning gets jeopardized if one CEO dies and if there is no succession plan for the key man in that organization. Then I think the BCM is not that strong in that particular organization. So
Okay.
that's my viewpoint,
All right.
Daman. So
Good.
I don't have any questions, and I must take the opportunity to thank all the panels. It has been a very, very, useful topic. So thanks, Daman,
Great.
and all the panels. Thank you.
Thank you very much. And if Shweta and Amitava, if you don't mind, switch on the cameras. Aniket also, if you can. I would like to take a picture. I hope no one has any objection.
I don't have any objection, but I'm not well shaved, Daman, so you have to excuse me
Even
for
I
that.
am not, so that's okay. It's Saturday evening, we all know. If you want to switch on the camera.
Yeah, I
Okay.
have. I don't know whether I'm visible or not. Yeah, thanks.
Which view, gallery view would be best. Yes. So I'll take a picture. Give me the best smiles, please. And I hope you don't have any objection in me sharing this.
No, I don't have.
Also, right? Thank you very much. Anand, Kamal, thank you very much once again.
Thank you very much.
Requesting all of us to clap for all of us. Participants, without you, it won't be successful. Panelists, without you, it wouldn't be successful. So great job, I will say. It's fortnightly activity. I'm keeping it as fortnightly. Daytime is fixed, Saturday, 8:30 p.m. IST. I haven't decided the topic for the next one, but I'll write to you all. And then attempt is that we have a different person speaking every time. So I request people to come forward with their experiences. It's fun come learn activity. It's not that I need to be an expert. I can just put in my views that this is my view about this topic. Not necessarily that this is correct view or this is my expectation. Maybe there is no one who's able to fulfill that expectation. So this is how I'm expecting everyone can be a speaker here. Thank you very much once again. And we'll see you in the next episode. Will be episode 8. Thank you. Bye-bye.
Thank you.
Good evening.
Thank you. Bye-bye.